Hello and welcome everyone to Area of Study 2 for Unit 3. Obviously, if you're watching this, you've hopefully finished or done your SAC for Area of Study 1, and I hope you did very well. If you haven't got your marks back yet, good luck for that. And without further ado, we'll jump straight into it. Unknown quote today. Progress has little to do with speed, but much to do with direction. And when you get your results for this first SAC, it is worthwhile reflecting on this quote a little bit, perhaps, and thinking about, do you know where you are trying to go this year, and do you know what outcome you want, and have you set yourself some goals? Because if you don't have that direction, I think sometimes our fallback is to try and work, I suppose, a bit manically at the last minute and do things that perhaps aren't the most targeted things in the world, and we cram and we study a bit frantically and we get a bit anxious and that sort of thing, and as a result our results suffer. So really take the moment based on your results from that first SAC to set yourself into some direction moving forwards. The study design is obviously split for Unit 3 between criminal law and civil law, and these two areas of study reflect each other pretty much straight through. So like with criminal law, how we started with the principles of justice, key concepts, and then worked our way through some pre-trial procedures like committal hearings into trial, so looking at the roles people play through to sentencing factors and reforms. The same deal will occur with civil law with Area of Study 2. So we start today with the principles of justice, and thankfully they haven't changed. They are fairness, equality, and access, hence this will be quite a quick video. And then from there we look at the key concepts in civil law. We'll look at some civil law pre-trial procedures. We'll then go into the roles that key figures play in civil trials before we go to civil remedies, and then on to reforms. So pretty much mirroring what we did for criminal law. Obviously, we're going to have to evaluate the ability of the civil justice system to achieve the principles of justice, just like we did at the end of Area of Study 1. So our essential question is pretty straightforward today. What are the principles of justice, and how does our legal system promote them? And as we know from Area of Study 1, hopefully, they are fairness, equality, and access. So, hasn't changed from Area of Study 1 to Area of Study 2. Fairness is still about impartial and just treatment without favouritism or discrimination. Equality is still the state of being the same in status, rights, or opportunities. And access is still technically the definition being the means or opportunity to approach or enter a place. So physically being able to get into the courtroom, so removing things like delays, etc. But with Area of Study 1 for access, we'll add that caveat of it is about understanding what is going on as well. So things that promote access are things that build an individual's understanding of their rights, build their understanding of how the trial is progressing, build their understanding of basically how they can resolve a dispute. So we have fairness, impartial or just treatment, so no bias, no prejudice. Equality, being treated the same, and access, either being able to get into the courtroom or having your understanding of what is occurring improved. How do we achieve these three things? Pretty similar, obviously, concepts to criminal law, but some slight changes in these slides than that first set we looked at. So, for fairness, we are still looking at that impartial role of the judge. One of the key roles of the judge is to be a fair and just adjudicator in a dispute. Apply the rules of evidence and procedure equally to both parties, so that'll come into equality as well. But particularly when we're talking rules of evidence, we are talking things like making sure that evidence isn't prejudicial, making sure that evidence doesn't build bias, that it actually is probative, that it proves something. And therefore, as a result of this role, the decision should be made at the end of the trial that is based on the evidence and arguments and not any bias or prejudice. The other one that builds fairness is the role of the parties, and we'll get to that later in the unit as well, or the area of study, but that's all about the fact that parties present their own evidence, they come up with their own arguments, and Obviously, because they're invested in winning, they should be presenting the best evidence and the best arguments. And this means that the decision made at the end, be it by a jury of 6 or by the judge, will be based on all of the evidence and all of the arguments that have been put to them, and won't be based on things like, their sex, their gender, their look, that sort of stuff. So it'll be a fair outcome, not a biased or prejudiced outcome. Strict rules of evidence and procedure are the same with equality, because both parties are treated the same and both parties have appeal avenues. You could also look at things like the court hierarchy, being, depending on the level of your case, being dealt with in the same court, so on and so forth. And finally, access. Access is really, really important in civil law, where you have an increasingly litigious society, meaning litigation is becoming more and more prominent. It's quite a regular phrase to perhaps hear people these days jokingly tell each other, "Oh, I'm going to sue you," etc. And as a result, there are increasing numbers of civil law cases that are going to courts as people know their rights. As a result, in order to improve access, we need to make sure more of these disputes can be resolved and more quickly, and that's where things like alternative dispute resolution avenues and methods promote access, because you should be able to have your case heard quicker if you go through VCAT or Consumer Affairs Victoria becomes involved. Same thing with things like mediation, conciliation. You might be able to resolve your dispute before you end up in the courtroom, and that can really link to fairness as well. Also, pretrial procedures, particularly things like discovery, so you can understand all of the evidence. There's an element of fairness to that as well as directions hearings, to basically clarify any issues and tell you what's going on, are all about furthering your understanding. So, to quickly add a little bit more detail about them, fairness, so impartial or just treatment, free from discrimination based on gender, cultural background, sexuality, or things just as simple as your look. One thing that we would have referenced in Area of Study 1 is the idea that, if you rock into court as an accused person and you have tattoos on your neck, you might be seen as being more likely to engage in criminal behaviour by a jury. The same thing needs to apply in civil law. If you are sued for causing damage to someone's property, or sued for causing damage to an individual, and you have a similar look to that, perhaps you look quite thuggish, you have a beard, etc., that is something that you could be discriminated on or against. So it's about ensuring that no matter your look, no matter your background, no matter your gender, that you end up with a decision that's based on evidence and arguments, not on that prejudice that people might hold. The judge has a big role in that, both in terms of if they are making the decision or if they are instructing the jury on how to apply the law. You should be presumed innocent, and this is obviously the presumption of innocence is very strongly related to criminal law and human rights and the such. But it's the same in a criminal dispute. If someone accuses you of causing them harm in some way, it should be assumed that you haven't caused them that harm until it can be proved otherwise in a court of law. Obviously, the standard of proof changes slightly, and you should know the evidence against you and the arguments that will be made against you, and discovery ensures that. So ultimately, this building to the idea that the decision made at the end is fair and it's not based on discrimination. So as we can see below, ensures the decision is based on facts and evidence rather than prejudice, bias, or other factors. And by other factors, I just mean like, an incomplete case. Like if you have substandard legal representation, for example, and can't present your case as well as you would have liked to, and you lose as a result, that's unfair, because if you had the same level of legal expertise perhaps as the other party, you might have won if all the best evidence was there. So prejudice, bias, or other factors. Equality, as we know, it's about being treated the same. So all parties are equal before the law. That means that no party gets special treatment in terms of the rules of procedure. No party gets special treatment in terms of the rules of evidence. And the processes and procedures followed from case to case are the same for all parties. Obviously, civil law allows some more flexibility around mediation, conciliation, etc. But you have control over that, and you have access to that just like any other party does. So equality, a bit more straightforward. But one thing that popped up in my class, and perhaps may have in yours, is the idea that when we are talking about equality in an answer, it is vitally important that we answer this question. Who is the same / equal? Because I often had my students writing responses that said, and as a result of this, there is equality. And I sort of was becoming frustrated because I'm like, that's just a statement. It's just a statement that this means that's equal. But who's equal? Okay, it's only a little change, but as soon as the answer says, and because of this, every accused person in the Victorian criminal justice system is equal, is vitally different to just saying this means there's equality. Because now I can see that you are saying that accused people are equal. Same thing with you've said all victims are treated equal. All witnesses are treated equally. So I can actually see who is equal and who is being treated the same, which is therefore really clear in spelling out how that achieves equality. So that's super important. Finally, there is access. As we said on the first page, it's the means or opportunity to enter a place, but also about understanding and knowledge. And that's very clearly said here. So people should know your legal rights. You should know how to resolve a dispute through the courts or other mechanisms. You should also be able to physically access courts or other mechanisms, so in terms of there not being unreasonable delays and that type of things. And your access to this sort of stuff shouldn't be limited by money, language, cultural barriers, and the like. So a little bit similar to fairness there. To ensure that you have a decision that is based on, again, you being able to put forward the best legal arguments, you being able to physically be in court, witnesses being able to remember things. Access is vitally important. Obviously, our final skill here is that we are going to evaluate the ability of the criminal justice system. Sorry, I have not edited that appropriately. That should be the civil justice system. But we can see how clear the mirroring is from area of study 1 to area of study 2. So the ability of the civil justice system to achieve the principles of justice. I've just put in those few from the first slide here now. The role of the judge. Equality, role of a jury is a good one here because everyone has access to a jury of 6 in the county or Supreme Court, but you could also use that to argue that there's not equality because it is optional. So not every case has a jury, particularly if you use alternate methods as well. So that's a good one that you can argue on both sides. Strict rules of evidence and procedure, people are treated the same. There's appeal avenues for everyone. Access, legal aid's only specifically taught in area of study 1 for criminal law, but you can go and see legal aid for that free legal advice about the civil matter you have. Pre-trial procedures, things like mediation, conciliation, enabling you to have your dispute resolved in a more timely manner are all about access. So, just really going back over fairness, equality, and access here with extra little references to specific civil law matters, but we're going to build our understanding as we go throughout this unit. So to finish off, what are our principles of justice? As we know, they are fairness, equality, and access, and hopefully at the conclusion of this video, you should be able to start coming up with a few things for how our legal system promotes them. This has been the Legal Studies Guy. You can, as always, provide me direct feedback through the Facebook page or email thelegalstudiesguy@gmail.com. I hope you all have a fantastic start to area of study 2, and I'll talk to you shortly.